responsibility, and they were offered basically a standard modification, but it actually increased their payment. And for a variety of reasons, that didn't work for them. And my client's objective was just to be able to keep a roof over his wife's head while she lived out the remainder of her life. So I called up the attorney for the bank, who was one of the big five, not the attorney, the bank. And I said, you know, why don't we just do a deed in lieu of foreclosure? The bank can have the house, but just reserve a life tenancy, a recorded life tenancy for my client's wife. And the day she passes away, the bank is entitled to immediate possession. And you know, this was truly my client's objective, despite the fact that he had a much longer life to live. He didn't care about the house. He wanted to leave as soon as she had passed. And the bank said no. And the reason the bank said no is because it was a Freddie Mac loan, and Freddie Mac just has, you know, regulations this thick about what kind of workout options are available for people, and it just wasn't a viable option. So then we went back to the table with a regular modification, and what they decided to do was just to pinch their pennies as best as they could and let other bills go so that she could stay in the house. And 2 months after, the loan was fully modified after a couple of years of go-arounds. She passed away. So now the deed and entitlement to possession of the home is still in my client's name, even though he's months and months and months behind now because the bank hasn't re-foreclosed. But had the bank been able to accept the deal, they would have had a house without having to relitigate all of that. But the rules are very onerous when we're dealing with HAND and when we're dealing with Fannie Mae and Freddie Mac. And I just want to speak a little bit about the mediation process, because going into mediation with a workout officer from a local bank who is there and has authority to settle with the bank's attorney, you're actually going to be able to have a discussion about negotiating. And all of the banks have, you know, underwriting policies, but it's a lot different talking with a person who has the authority to make a workout option than a service representative on the phone who got handed the file 5 minutes before he or she got on the phone. You know, I went into these mediations initially thinking, well, this is just going to be like a family law mediation. You know, you go in and talk about each person's position and you walk away with a settlement and no one's happy, but it's okay. And that's not the case. It's more of like a facilitated conversation about what the rules are and what the borrowers have to do to comply with the rules. But don't forget that the rules don't apply to the big banks. So,
you mean the hand rules?
Right, I'm being completely sarcastic.
In case you hadn't noticed.
In case you hadn't. So, what I don't think it's been litigated. The issue about whether or not the bank's servicer representative on the phone actually has authority to settle a matter, but I am very confident that the person who is on the phone at a mediation, in fact, doesn't have authority to settle, and I think everybody knows that in the judicial system anyway. You just go through the process, because if the process is done correctly, more often than not, the borrower should walk out with a modification if they truly are eligible. And when the banks do not comply with agreements that are made at mediation or do not follow the Reg X rules that Andrea talked about, the mediators have some discretion about whether or not to issue a report of noncompliance, and the mediator can pass that report along to a judge. And then it's a matter of discretion for the judge to either issue a sanction or not issue a sanction. I've had some cases where mediators refused to issue a report of noncompliance because they didn't really think that that was going to do anything to bring the parties together and actually mediate. And I said, well, that's not really what happens anyway. So I've just filed my own motion for sanctions, and I've had those motions granted. And what I use the orders for is to get the bank to come to the table and work with us and to follow the rules so they don't get their case dismissed with prejudice. And whenever I have a sanctions order, the file somehow ends up at a different attorney's office, and then we have a modification within a week. So that's how I use the sanctions process, and also to get maybe some principal forgiveness or some cash for my client for the fees. Andrew and I mean, I like getting fees for legal services for the elderly, but it's not, you know, my goal because I don't rely on it for my livelihood. Let me just see here if I'm forgetting anything.
I know we're supposed to hold our questions, but I'm not going to. So when you file a motion for sanctions,
Yeah.
is that litigated, and do you just say, here's what happened in mediation? Do you call the mediator?
No. So, well, yes, and so here's what I did was, and I haven't actually filed one for a very long time. I mean, I have one foreclosure case right now. Since we all got greenleafed, we have like no work in the foreclosure program. And
I still do.
okay, I have one case at the law court right now, and that's it, and it's a community event case. But it's a whole other litigation can of worms. That has nothing to do with what we're talking about here today. Okay, so what I would do is I would file a motion saying this is what was agreed to at mediation. I'm not going to go into what happened at mediation because that's confidential under the rules of evidence. But when a bank agrees to review a loan modification request packet within 60 days and they don't, 10 times over, you know, it's a waste of the court's time, it's a waste of the mediator's time, it's a waste of my time. My clients are going bonkers because they have submitted this paperwork over and over and over and over again. So I will just say, this is what was agreed to, here are the points of agreement, it wasn't done. Here are the points of agreement. And I have only, I think I was filing these motions before like the sanctions litigation kind of took off, and they weren't heard. But I think that they would be now, and I think the evidence would be put on now. I don't think the mediator should be called. I think the homeowner could be called.
So it's more to enforce an agreement that has
Yes.
resulted rather than a failure to mediate in good faith.
Well, I think that promising to do something, you know,
Yeah.
I mean, over and over and over again. You know, if they don't do it once, you know, I'm not going to say that that's bad faith. I'm going to say maybe it was a mistake. But when the same bank is doing it in every single case I have, and it's the same pattern and practice of we're going to lose your documents, we're not even going to review your documents, we're going to say that you're denied when you're not, and it's just this, you know, I could go on, I could tell you many more stories, just like you know, I can't speak to whether or not the local banks have a little bit more leeway in terms of what the workout options are, but one piece of advice I would have for those of you who would like to help homeowners is get yourself acquainted with the rules, with the Freddie Mac rules, the Fannie Mae rules, the FHA rules, the VA rules, the HAMP rules, and et cetera, et cetera.
Get a lot of coffee.
Yeah. And by get familiar with them, I mean call somebody who can point you in the right direction. Like, I'm not going to say like Andrea, but Nicole. But yeah, so someone like, I mean, you can call me if you want to, and if you have if you're like, I don't know if we can do this, you know, can you help me find the regulation on point that would help me figure this out? Give me a call. I'm happy to help. The one thing that I would ask maybe Nicole to touch on a little bit is and with my clients, showing income is relatively easy because most of my clients are on Social Security retirement. So I just need to provide their annual benefits letter and show their direct deposit for 2 months, and then their income is proven. One other tidbit is that some public benefits are considered income, which can either help or hinder a person depending on where they're at on the HAMP eligibility line. But I believe food stamps counts as income. I don't believe unemployment does, but SSI does. I don't know about TANF because most of my clients aren't on or don't need TANF. Let me just see. I have never had a trial, a foreclosure trial. We've always settled, sometimes on the eve of trial, because if there is a defense, I've pointed it out to opposing counsel and they say, oh my goodness, you're right, we gotta figure something out here. And by the eve of trial, I don't mean like the day before, I'm calling the opposing counsel and saying, guess what, you're gonna lose tomorrow. I mean, I've been trying to point it out for the whole time, and finally it sunk in. So anyway, we've worked, I have to say that the foreclosure diversion program has enabled legal services for the elderly to save many, 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 many homes. I haven't ever gone into a foreclosure diversion mediation where I was confident that my client was going to get a modification and we didn't walk away with one. Sometimes it took some wrangling to get there, but the benefit of the program and the judicial oversight that is provided with the program is invaluable in Maine, and I hope it never goes away.
I'd like to interrupt just for a sec, because there was a point there that I think Bruce spoke with Betsy briefly about. Bruce, what I'm talking about is when your community banks have sent the loan and the mortgage on to one of the alphabet soup things, you're servicing, and then a problem occurs. Did I understand correctly that sometimes your bank tries to get the papers back? And could you discuss just briefly what the thinking is and why you're doing that? Because I think this is useful to you in figuring out who are you dealing with, you the lawyers, and different ways to deal with different banks.
Yeah, the community banks, if in fact they are basically selling these loans to the government, to Freddie Mac or Fannie Mae, they're not transferring it to the Big Five. They're transferring it to a governmental quasi-agency, and that depends on what bankruptcy court you're in front of and whether or not it's really a governmental agency or not. But so they become the servicer for it. I was in Judge Haynes' courtroom on a motion for stay relief because the debtor was 2 months post-petition behind. He'd missed 2 consecutive months post-petition. And Freddie Mac required that I file a motion for stay relief because they were 2 months behind. Judge Haynes didn't particularly like that and wasn't going to grant stay relief, so my bank went back and bought the loan back from Freddie Mac. Those requirements, I think you're right, you need more than a lot of copy. You can look them up at allregs.com or .gov. There's 3 ring binders this thick. So the ability for the community banks to take them back and gain control, they don't like to do it because the servicing fees that they give for these agreements with the government are lucrative for the bank. They like to do it, but it's easier to do it on their own terms, primarily because Freddie Mac has a deadline of how quickly you have to bring this foreclosure to completion. And if you don't get it done, and Maine is, the last time I looked, was the 3rd slowest foreclosure state in the country. They had extended it to 860 days. If you can't complete it in 860 days from the notice of the right to cure, the 6111 notice, you get fined daily. And the banks aren't going to start paying the government for being late, so they will, we calendar it, so we get up to 750 days or something. We call the bank, or call them and say, hey, we're running out of time, we're not going to get there, so we can buy it back. Just quickly on the Freddie Mac requirements that make no sense. I had one that we took the foreclosure to auction. Prior to the auction, a third party came and made an offer to buy the property, which was greater than the principal balance of the loan. I did include all the interest and all the fees, but it was more than the principal balance on the loan. Freddie Mac looked at it, came back and said, no, we won't take that. This is the number we want. The number they want was $10,000 more than the judgment amount. So, of course, the potential buyer walked away from that. We went to auction. The potential buyer showed up and paid 50 cents on the dollar. And that's our tax money at work. That, you know, they could have had this property, you know, and done with it, but instead they didn't because the regs were what they were. So it makes no sense.
One more, I just want to speak to that too. I mean, you know, when you're dealing with Freddie Mac, you know, who's going to come to the mediation that has authority to settle for Freddie Mac? I mean, who's going to say, oh yeah, I can waive this regulation for you? Oops, I should have better guessed that. The other thing I wanted to say is that I have worked with community banks when they've been a second lien holder for like a home equity line of credit. And it's been really great when there's a local bank as the second lien holder. In some of my cases, where in particular, I had a client who was unemployed for a period of time and then got a really great job and was so sick of dealing with Wells Fargo. He wanted to just pay off the loan entirely, and what we did was we worked with the second lien holder to refinance the whole kit and caboodle, the first lien, the second lien, and arguably the second lien holder could have been at risk of just losing everything, but they worked with us to just shoo Wells Fargo off the table, and we had to refinance with the second lien holder, community bank. And one more thing about working with elders, some of these loan modifications re-amortize the loan like out to 40 years, and it might be a huge consideration for someone who's in foreclosure, maybe at the age of like 30, 35, 40. But with my clients who by definition are 60 years of age or older, when I'm telling them you're going to have this $100,000 balloon payment at the end of your mortgage, or you're going to have to pay this for 40 years, they're like, yeah. And, it's almost like their mortgage payment is their rental payment at that point. They're never going to have equity again. It's not a nest egg. But the question to ask him or her is this how much you would pay to rent your house, for staying in your house, as opposed to like moving on to a different apartment or something? And I've never had someone say no. They realize that the equity's gone, and this isn't a legacy to leave the kids. I mean, the kids could try to assume the mortgage afterwards if they wanted to, but they're focused on just staying there to live out the rest of their days as best they can.
Does anybody on the panel have anything else they want to throw in right now? Yeah, go ahead.
Just a practice tip, if you are thinking of doing this work, on certain dates in the different district courts, they have informational sessions before the mediations. And they're given by HUD certified counselors. I don't know if do you give one?
Oh, yes.
Nicole. And they're a font of information. It's a great overview of how to do a loan modification and the information you need. It's fantastic, and it's, what, half an hour?
Yeah, an hour, 40 minutes.
Yeah, and it's perfect. So it's a great primer, free, go and sit in and listen. You'll learn a lot.
And I have a PowerPoint handout that I give people, so if anyone wants it, you can get my email from Jim.
Is that this?
No, that's
another.
It's so I'm happy to email it just for the basic information.
Okay, just let me know when you touch with me. Anybody in the audience have any questions? Yes.
Without going too much into specifics, I'm wondering how much have the Greenleaf cases actually affected your practice, and how often you come up against cases that, there was a MERS assignment back there somewhere and you have to work through it.
Just so that the recording gets at, the question was, how much have the Greenleaf line of cases affected the practices?
So I just want to, as a housing counselor, so I'm not doing the legal stuff, and the way that it's affected me is sometimes clients, I'll be working along with them, and then they're like, hey, my foreclosure just got dismissed, and now I don't ever have to worry about this again. And then trying to explain to them why it was dismissed and why they do have to be dealing with it, and the delinquency doesn't automatically go away, has been an ongoing, that's kind of stopped. The banks are starting to try to do weird things to get around it, but that was causing a big, because I'm not doing the legal side of it, so explaining Greenleaf was.
Just, you dropped it. What's the weird thing you were telling me about that one of the big banks was trying to do? You can tell me something odd.
Yeah.
Because since you raised Greenleaf.
They were trying, a declaratory judgment against, so my homeowner was listed as a party of interest, and the declaratory judgment was being filed against the bank that had been
Transferring.
Yeah,
The originator.
the originator, and that's how they were trying to get around it. But unfortunately, the confusion too is they served the homeowner and they served them with the blank form answer to the complaint to get into the mediation, even though that should not have happened. And so it was just, it caused like a whole, lots of back and forth. They got an attorney, my homeowner got an attorney, so now they're dealing with that.
From my perspective, Greenleaf 1 created a whole host of issues from the bank's perspective, in particular in relation to the 6111 notice and demand for payment, because it had been my practice for years and years and years to add per diem. Your default as of March 14th, here's how much you owe, plus accrued interest at the rate of $11.63 for each day until you pay us. Greenleaf changed that, so you had to change your 6111 notice to say it's got to be a fixed number. The problem becomes, because it's a 35-day notice, next month's payment's going to come due. But you can't tell them that, so the question was, did you have to send another 6111 notice? And it was just a sort of repetitive headache. But sort of kind of Greenleaf 2 has fixed some of that, but it did create some havoc. It created a lot of anxiety amongst the banks about what is Judge Gorman talking about. But it created a lot of issues, and I think on top of all of that, not just Greenleaf, but all of the cases from the law court, particularly when they had the two law clerks who were reviewing summary judgment motions. It's the only area of civil practice where a Rule 56 motion can get denied even though the other side hasn't objected to the statement of material facts, hasn't admitted or denied anything, but just because you may or may not have touched all the bases, they'll deny it, even when you've defaulted the borrowers. So, it made it very difficult for community banks. And again, I don't disagree that the things that are out there were happening with other lenders, but for the community banks, when you're filing summary judgments and you've got the original note, you've got all these things, it still became difficult, which is why I had contested hearings.
I see it a little differently, obviously, than Bruce. Greenleaf did provide us with a lot of tools to use for our homeowners, and on our side, I believe that it finally made the banks stop and look at what they were doing and try and do it right. They still haven't gotten it quite yet, and I think they're working on it. We've seen all kinds of different practices happening trying to fix the bank's issues in Greenleaf, like the declaratory judgment motions, going to federal court. Now they're trying to go to federal court to avoid the mediation program and get declaratory judgments. I mean, they're trying to do what they can to get around it. But we're keeping up with them, so I think we'll give them a run for their money. But Greenleaf did slow down foreclosure, so in that sense it did affect our practices, that we didn't have as many people coming through the door. But it did create a new type of practice of foreclosure defense and having some real defenses to use when you go to a foreclosure trial. And there is a provision in the main statutes that allows for fees if you are the successful party at the trial. So you can do that work too and sustain it if you're successful.
One thing that's nothing to do with Greenleaf, but that I wanted to point out is that the mediation program, I think, is really beneficial to both the homeowner and the bank in a lot of situations, and in the community banks, because sometimes that's the point where the homeowner discovers that there are resources that they can tap into, like housing counseling or free legal services, even though that sheet should be sent with their notice of default letter, like the list of HUD counseling agencies and other services. They're not the best at reading their mail when they're in stressful situations, so that sheet may or may not end up in the garbage, and at the information session is when they first find out that, hey, there's free help that they can access to sort of work out the situation. And even though it shouldn't be the way they think in their head, like the bank is the bad guy, the bank is the bad guy, even with the local banks, like sometimes, like I had this one guy that even though his local bank was being great and trying to work with him, he just thought that they were out to get him, and he didn't want to do anything. And then finally he met me at mediation, and we were able to have a very constructive conversation with his local bank, and he got a modification, and it's been a year, and he's hanging on it, and all is good. So I think that getting there can be a really helpful thing for a lot of homeowners.
I don't disagree with that. I think particularly with pro se borrowers, either if you have the opportunity to assist them as a clinic lawyer or a private practice lawyer, but when we get the housing advisors, CEI has to come in, it helps because the communication with the pro se defendant, that they're looking at the bank and they're lawyered up with some guy with gray hair, you know. So having you speak to them really sort of breaks down the wall, and it really does help.
Other questions? Yes.
So it seems to me when the borrowers walk into your door that there's three main moments that they're coming to you. One is perhaps somebody who's either experiencing financial difficulty or is about to, so there's this foreseeable future moment for them. Maybe the other type of borrower is somebody who has defaulted, but there's no foreclosure action right now. And then the third maybe is the person who does have a foreclosure action, you know, maybe hasn't been checking their mail. So how do those three people get addressed differently when they walk into your door?
I run them through the same sort of process, like do a financial analysis, try to find out what they're eligible for and if they have the income to support that, because sometimes not everyone can keep their house, and sometimes you have to have that hard conversation. But for the people that aren't yet delinquent, it is a conversation of keep making your payment in whatever way you have to. I don't care if you stop paying your credit cards, like that's not important. They can't take anything from you. Stop paying on your Visa. So keep making your mortgage payment. We'll try to work with a mortgage company to lower your payment. And for the people that are just a little bit delinquent or already in foreclosure, one thing that I tell both of them is to start saving your payments. And if they can't, if they say, hey, I can't set aside what I think an affordable mortgage payment would be, then my conversation is going to be, well, this might not be, you might not be able to save your home. If you can't set aside an affordable mortgage payment, then we need to start talking what your other options are. But the process of retention options is almost the same for all of them, depending on who their servicer is and who their investor is.
So I'm sorry, I'm like shamefully ignorant, but are you advising them don't make a partial payment?
Partial payments, I don't really see any benefit to, because
It's probably if the complaint has been filed, because
Oh,
if
yeah,
you
that's-
accept,
then
if
it's
you,
like,
if you accept the partial payment without an agreement to do it, it stops the foreclosure.
Right.
So, but if they're delinquent, but there's been no litigation commenced?
If they're only like a month or so delinquent and they want to send in a partial payment, that doesn't do anything. They'll just put that in a suspense account until another payment comes in to satisfy the rest of what the normal mortgage payment would be, and then it will get applied to the loan.
So do you actually advise them, look, rather than doing that, if you're thinking about doing that, just put the money in a bank account and try to save it?
No, that's more, no, I wouldn't tell them to stop. I'd advise them to keep throwing monies, but.
Okay, but when you're saying try to set aside what you think.
That's if the mortgage company stops accepting payment.
Okay, gotcha.
Yeah, if they've stopped accepting it, doesn't mean that you get to do whatever you want with it.
Because if the mortgage company were to accept,
Yes.
that waives the right to proceed with it.
If the mortgage company works something out,
Right.
then you want to have that money ready. And some of the really yucky mortgage companies out there, the really bad servicers, will request good faith down payments before a modification can be accepted. And I've had Caliber, I'll just say their name, ask for $12,000 of a good faith down payment. And that's ridiculous and impossible, and as you can get around that. But if a good faith payment is requested, it's nice to have that there.
You know, I just as we're talking, another potential solution, which a lot of times causes problems from the borrowers, is something called a short sale, or just a private sale. Because my bank clients will encourage the borrower to sell it themselves, find a buyer, and come talk to us if you get an offer. Because if I have to do it through foreclosure, we're gonna get 60 cents on the dollar, 50 cents on the dollar. And the problem becomes that it should be something from your perspective when you're talking to them, is don't get so hung up that the house is, you think the house is worth $325, and you got an offer at $310. You know, take the offer, from my perspective. They get so hung up, but I'm losing $10,000. Well, you're gonna lose everything if you don't. Or come with a short sale. You owe $325, you got an offer at $290, bring it to the bank, we look at it, we can do it. If it makes sense, as opposed to running up $8,000 or $10,000 in legal fees and waiting 18 or 24 months to get to there and having no taxes paid, we have to pay it anyway.
And heat it through.
Exactly. The short sale or the private sale, whether it's short sale or just break-even sale, is an option that a lot of people just have a hang-up with because they can't pull the trigger that says, oh, it's worth more than that. Well, you're in trouble. So that's just an option that is out there that lots of times that it doesn't get considered very seriously, and the banks would be willing to do it.
And I do just want to mention one other option for saving the home is bankruptcy, and I would be remiss not to say that. Judge Hayes, but bankruptcy can save your house, Chapter 13. They can repay the arrears over a 3 to 5 year period of time, and so absolutely a consult with a bankruptcy attorney is recommended for anybody who is in or facing foreclosure.
I recommend that people go talk to Andrea all the time. Me too. I mean, particularly, you know, if someone's already been through the foreclosure diversion program and they have a HAMP modification, it's not going to get any better than that. Yeah. And then if you fall behind with a HAMP modification for, you know, illness or whatever, more likely than not, your best bet is to go talk to Andrea about a Chapter 13 to keep your HAMP payment in place. Because if you default on HAMP, well, I'm not. So one other thing I wanted to just say about legal services for the elderly, we're going to refer callers to our helpline to the community housing counselors before a complaint is filed. Once a complaint is filed, then a lawyer will enter an appearance if we think the case has merit, but before that, our helpline attorneys are referring to CEI and Avesta and York County Community Action and all of that. And if we identify any FDCPA violations or any other defense or whatnot that is likely to yield attorney's fees, we're also referring that out because we want to help folks who can't get attorneys. And when you have attorney's fees on the table potentially, the private bar is more apt to pick up those cases. So if I have a glaringly obvious foreclosure defense, I'm going to pass it along to somebody in the MASH or give Andrea a call. If I see that something has happened post-modification that is not correct and notices of error don't resolve the problem, I'm sending it over to Andrea so that she can get the fees because legal services for the elderly has other means by which to fund our organization. So that's, we're not in the business of suing for damages and all of that. So.
Other questions?
So something you had said, I think, Liz, was that mediation's a lot like a facilitated conversation about the roles. And I found that really fascinating because one of the mediations I had sat in with Nicole, the bank lawyer dialed the phone number for the loss specialist and then did nothing else, said nothing else, I don't think really spoke at all. And so this again, I think is a question for all of you, but you know, maybe even starting with Bruce, is that so I'm curious as how, if I am specifically representing the borrower, how a lawyer can go to that mediation and I'm trying to think how to say this, but how to facilitate that conversation, and then maybe from each of your perspectives, how, you know, what a lawyer can do to get the best outcome for their client in this. I think you mentioned communication's important.
Yeah, I think that whether it's a housing counselor or a promoter or a clinic attorney that comes to facilitate the conversation with the borrower, because the vast majority come in either with their radar up that this is the big bad bank, even if it's a community bank, and they're trying to throw me out of my house and they're not listening to what's being said. to facilitate that and sort of break the code down and talk to them is really helpful, and it encourages more of a dialogue that we can talk. You and I can talk, and then you can explain it to your client instead of me, and the white noise comes and they don't hear anything I say. So with the Big Five, it's not any different if you try to call one of the local attorneys representing them. You will not get an answer. They will say, here's the 800 number, or you won't even get through to them. So I can say, I give out my direct dial number. If you got a question, call me directly. We can walk through it and we'll get you an answer. Even if we can't do it, I'll at least tell you why we can't do it, or here's the option. So I think really the point being is that it facilitates the conversation if you can sort of break the code and run interference and be a buffer between the bank and the client.
I got a question for Andrea that keys off that. If you are dealing with one of the non-cooperators, can you use this to start setting up the other cases? And if so, how would the homeowner's lawyer go about setting up
I would
this
never do
level?
that. Absolutely. So what you want to make sure is you have a very detailed mediator's report as to everything you agreed upon in that mediation. You're going to have a report that lays out all the deadlines you've agreed to, all the information you agreed to, if they're being non-cooperative, or if they ask for a deadline which is 60 days instead of the Reg X 30 days, you want that noted. I mean, you want everything noted in that mediator's report, and then when they don't abide by it, you can hold them to it. You can say, you agreed to A, B, C, D, you didn't do it, so let's try again. I always give them at least one chance to fix their errors. And then if we agree to another deadline and they miss that one, then we're looking at a non-compliance report, and I will ask the mediator to issue a non-compliance. Sometimes they do, sometimes they don't.
It actually works both ways, because the mediators are almost always willing to put as much detail into the report that you ask for or the bank asks for, and to the same extent that if there's deadlines for the borrower to come up with X, Y, and Z and they don't, I can write to the clerk and say, put it back on the docket. That gets their attention pretty quickly. Or they've thrown in the towel and it's back on the docket, they can't do anything. But working with the mediator to get those detailed deadlines and as specific as you can is helpful for both sides.
Know the rules. If you have a if you have a Freddie Mac loan modification, if you have a Freddie Mac mortgage, have a really good idea about what modification program the borrower is going to be eligible for and the backup to that. Bring the appropriate regulations with you. Yes, the Freddie Mac regs are this big, but the loss mitigation regs are like that big, so you can actually print those off and bring them with you. And confirm with the representative on the phone, this is a Freddie Mac loan, it's my understanding that we're gonna look at this, 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 and this, correct? And then they're gonna know that you know what you're talking about, but it's also to confirm that they know what they're talking about. And the mediators get training on the various loan modification options as well, so the mediator should know what you're talking about. And you shouldn't really have to be facilitating the conversation. The mediator really should be facilitating the conversation. But what you can help to do with your client is explain to him or her exactly what's going to happen, because, well, not exactly what's going to happen, but what to expect, because these mediations kind of go along the same track and they don't usually veer off course too far. So you can say, we're going to get the representative on the phone, we're going to talk about what the workout options are, we're going to talk about what you need to bring to the table as far as documents, we're going to talk about how long they're going to have, that kind of thing. I think that the borrowers also need to be educated that they're not going to be able to make an offer. It's not like you walk in and you say, give me 4% interest in a 30-year extended amortization. I mean, it just doesn't work like that. And I just echo everything Andrea said about making sure that the points of agreement are clear and in the points of agreement section.
Well, and about knowing the rules, when you're in a conversation with the servicer on the phone, you can say, well, have you evaluated for this, 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 and this? And they can say, no, we evaluated for this and we denied, and this is why, and that's all we have to do. And then you can say, no, you have to do this, this, and this too, and it's right here in the reg. I mean, we do that a lot. We point out to them what the rule says and what they're supposed to do. And that does happen a lot, mostly with the larger servicers. I mean, by the time I get involved with the community banks, there are problems, so my tales with them aren't all rosy, but they are much more responsive, I will give that to Bruce, and they do not require the document chase like the big servicers do. The problem I've seen is that the responses are usually no, and by the time they get to me. So the rules are a little stricter in that they don't have to comply with HAMP. They don't have to comply with the Fannie, Freddie, VA, whatever guidelines if they're not servicing for them. And so in a HAMP, if you're divorced, you provide the divorce decree and a quitclaim deed, and you can get a modification based on your income. With a community bank, you usually can't. That ex-spouse has to participate in the modification process. And that's going to be really difficult to get an ex-spouse to provide her income and her pay stubs and her information. So, you know, it goes both ways where they're much more willing to look at the documents, try and find a solution. They do have their rules too that sometimes don't correspond with what our borrowers need.
Nicole, you wanted to respond to something Liz was
Well, I
saying.
was just smiling because the mediation that Betsy and I were in, like where it helps to know like the rules and understand what sort of, like who your investor is, because that's going to dictate what guidelines the servicer needs to follow. That particular servicer, NationStar, they
Not mentioning
didn't
names.
understand this was a Freddie Mac, it was a Freddie Mac loan, and yet they were asking, the woman on the phone was like, I need the 7-page RMA, I need the 710 form. She was asking for forms that I knew were completely unnecessary and that they didn't need. And so instead of elevating as I could have and been like, no, we're not giving you that, like, it just seemed better, especially with the client being there, because clients don't understand what's going on a lot of the time. They're nervous, they're anxious, it's emotional. So I was like, okay, so even though it's a Freddie Mac loan, you still need the RMA? Yep, okay, we'll get that to you. It's like, fine, I will shove every piece of paper you ask for in your face, but if you make a problem with this, if you come back and then say, well, we didn't need, or something doesn't match the RMA that the 710 says, then I think we have a little bit more grounds to make an argument. But if they're asking for something, and even though you want to yell at them and say, that is absolutely not necessary,
and when you're dealing with entities that are not non-GSE entities, like private investors in the alphabet soup, you know, trusts that who knows who the heck owns the mortgage, what you're going to want to get is, you know, if the servicer on the phone is saying our investor guidelines restrict us from modifying this loan, what you're going to want them to do is agree to provide you with a copy of those guidelines. Because it's hard to find them. You have to go to the SEC and look for, you know, all these forms that have numbers and letters and all that. Sometimes you can find the pooling and servicing agreements on the SEC website. They are relatively difficult to find, I would say. So, I mean, there are like forensic experts that go look for these things for big bucks. You know, and I'm sitting here like Google SEC, trust number 880, you know, -LE-XYZ-2032, mortgage-backed trust security 2008. You know, it's like, you can find them. But make them get you those documents and make them agree to get you those documents at the mediation, like within 30 days or 10 days or something like that, because they'll probably fail.
And that sets up maybe for the tort cases that we also talked about. Jim, you had something?
Yeah, there's something that Bruce said that maybe inadvertently cast some light on this. It kind of seems like madness, and don't understand why there are all these delays. And so hard to get your handle on things. So sometimes you just go, these are such big enterprises with the packaged loans and stuff, but, you know, like in the late 70s, early 70s, credit card companies figured out that it's better to have like bad credit card debt and charge fees and interest and late charges than it is to just go to judgment and cut off the credit. In the mortgage world, it used to be, you're going to get a stream of payments, but if you don't do that, real estate was always appreciating, so you're going to get it back from your collateral. With divorcing these servicers who make their money by servicing the loan, and in the face of declining real estate values where you're not going to get the money from foreclosure, the longer you can play this out for the servicers in, they continue to touch the file, they continue to get fees, and the entity, whoever the hell it is who owns the mortgage, doesn't have to go reconstruct the pattern of assignments and foreclose on something that's going to be a loser. So there's really a method to the madness to wring as much money out of the process as possible through delay and diversion. And that's largely because the servicing has completely different economic incentives than mortgage ownership, and we've divorced servicing from ownership now. And it's just interesting when you're dealing with these people to figure out what's motivating them and what isn't. To the extent, and I want to know if Andrea does this, sure you do, those are still agents for the principal.
Yes.
And so to the extent you can bring home to the big 5 banks the fact that they're going to be responsible for the mishandling and overcharging on the file by their servicers, who are separate entities, but nonetheless they're agents, that's a way to get their attention and actually get some movement.
It's true. I always name the owner investor in my lawsuits as the agent, as the principal of the agent who's the servicer. I always name them because they will usually be represented by the same attorney, but you know the trustee of that trust or the owner of that loan is putting a lot of pressure on that servicer to get this resolved. And I see as soon as I get them both involved, it goes to a national law firm, and you know it's out of Maine by that point, and we get some results because they know, and they don't want to be in front of a jury, and they don't want a jury to hear what they're doing to consumers.
That segues nicely into what will be the end of today, because it's 2:45, but maybe the next one of these we do will be other forms of litigation when the foreclosure doesn't go well. If you have any ideas of things you'd like to have us discuss more, let me or Betsy know. Betsy's the one at the clinic who's the student in charge of the Homeowners Assistance Project. If you have any questions, let us know. Thanks a lot for coming, and we hope to see you later.